The courtroom was too quiet for a place where lives were about to change. I sat alone at the long wooden table, palms resting flat, spine straight, eyes forward. Across the room, my mother stood as if she owned the space, chin lifted, shoulders squared, voice already trembling with practiced concern. When the clerk finished reading the case number, she didn't wait to be invited to speak. "She cannot be trusted to manage her own affairs," my mother said, pointing directly at me. "She never could." The words hit harder than shouting ever would have. Not because they were loud, but because they were delivered calmly, like facts already agreed upon. A murmur moved through the gallery. I didn't react. I didn't turn my head. I had learned early that reacting was what she wanted. Emotion made her believable. Silence made her nervous. The petition wasn't supposed to be about me. On paper, it was about my late grandmother's estate. In reality, it was about erasure. If I could be declared unfit, unstable, incapable, then everything my grandmother left behind could be reassigned, reinterpreted, reclaimed. My name is Lena Hart. I was 35 years old, financially independent, professionally licensed, and according to the woman who raised me for 14 years, suddenly incapable of basic judgment. The judge listened without interruption. That alone told me this wasn't going to end quickly. My mother painted a careful picture, a fragile daughter, a history of emotional issues, concern for everyone's best interests. She used words like worry and safety. Anyone unfamiliar with our past might have believed she was brave for standing there. I said nothing when the judge finally turned to me. "Miss Hart," she asked, "do you wish to respond?" "No, Your Honor." The silence that followed was uncomfortable. Heavy, I could feel eyes shifting toward me, searching for weakness, waiting for a crack. There was a time in my life when my mother's words would have destroyed me, when being called unstable would have sent me spiraling into defense or shame. But that time had passed, long before this hearing. What my mother didn't understand was that silence wasn't surrender. It was strategy. Because while she was telling her version of my past, she had no idea I'd spent the last several weeks doing something far more dangerous than arguing. I'd been listening and watching and documenting. The judge leaned forward, folding her hands. Her gaze moved from my mother to me and then back again. "Counsel," she said slowly, turning to my mother's attorney, "before we continue, there's something I need to clarify." That was the moment I knew this hearing wasn't going to unfold the way my mother expected. And it was only the beginning. The judge's question didn't sound threatening. That was the dangerous part. My mother's attorney adjusted his tie before answering, confident, relaxed. He'd come prepared for tears, for emotional rebuttals, for a daughter unraveling under pressure. He hadn't prepared for quiet. The judge didn't ask about my childhood. She didn't ask about therapy records or medical history. Instead, she asked something far more precise. "Why," she said evenly, "was this petition filed 3 weeks after the estate entered probate?" The room shifted. My mother glanced sideways at her lawyer, just for a second. It was small, but I saw it. I'd seen that look before, when she needed someone else to take over. The attorney cleared his throat. "Your Honor, the timing is coincidental. My client's concerns escalated once she realized the scope of the estate and—" "So," the judge interrupted, "after she realized she was not the beneficiary." Silence. Not the awkward kind, the surgical kind. My mother straightened. "This isn't about money," she said quickly. "This is about protecting my family." I almost smiled, because that was the lie she always chose when the truth was too close. The reality was simpler and uglier. My grandmother hadn't just left me her savings. She'd left me control, full authority, no conditions, no shared oversight, no room for reinterpretation. And my mother couldn't stand that. What she also couldn't stand, what she truly feared, was that I understood systems, paperwork, patterns. I worked in compliance auditing. I made a living finding inconsistencies other people missed. I wasn't emotional about numbers. I was ruthless with them. That's why she hadn't challenged the will directly. She challenged me. If she could discredit my capacity, she wouldn't need to fight the documents. She could bypass them entirely. The judge leaned back in her chair, studying the file. "Miss Hart," she said, turning to me again, "you've chosen not to respond so far. Is there a reason?" "Yes, Your Honor." Every head turned. I wanted the record to be clear before I spoke. The judge nodded once. Go on. I took a breath. This petition isn't about concern, it's about access. Specifically, access that was cut off after my grandmother revised her accounts. My mother shook her head sharply. That's not true. Then the bank records will support that, I replied calmly. Her lawyer stood. Objection, speculation. The judge didn't even look at him. Overruled. That was the second shift. Subtle but irreversible, I continued. In the last 18 months of my grandmother's life, large withdrawals were made in cash. Not by me, not by the estate, by someone with informal access. I didn't say my mother's name. I didn't have to. The judge's pen stopped moving. My mother's confidence faltered, not dramatically, but enough. Her hands tightened in her lap. Her foot tapped once against the floor. She was calculating now, not performing. What she still didn't realize was that I wasn't here to defend myself. I was here to change the direction of the room. Because once you understand why someone accuses you, you stop reacting to the accusation and start examining the motive. And motives leave trails. By the time the judge called for a brief recess, my mother was no longer looking at me. She was staring straight ahead. And for the first time, I knew she was afraid, not of losing control of the estate, but of what I might already know. Because while everyone else thought this case was about mental fitness, I had already started uncovering something far worse. And the next thing I found would make the accusation against me completely irrelevant. The recess gave everyone exactly 15 minutes to pretend nothing had shifted. My mother left the courtroom first, heels clicking too fast for someone who claimed calm concern. Her attorney followed, already whispering reassurances that sounded more like prayers. I stayed seated. I didn't need air. I didn't need comfort. I needed clarity. Because once the judge asked why now, the story stopped being emotional and started becoming mathematical. And numbers don't care who raised you. While the courtroom emptied, I opened the thin folder I'd brought with me. No dramatic exhibits, no thick binders, just copies, clean, chronological, boring to anyone who didn't know what they meant. 2 years before my grandmother died, she added my name to her primary checking account. At the time, it was framed as convenience. Arthritis, transportation issues, someone to help with bills if needed. I hadn't questioned it. I trusted her. That decision was the only reason I could see what no one else had bothered to look for. Late one night, weeks before the hearing, I logged into the account from my apartment. At first glance, everything looked ordinary. Utilities, groceries, insurance premiums, the same predictable rhythm she'd kept for decades. Then I widened the date range. That's when the gaps appeared. 7 withdrawals, all in cash, all unusually large, none tied to routine expenses. No notes, no corresponding purchases, just clean disappearances. I didn't panic. Panic distorts judgment. I built a spreadsheet, dates, amounts, locations. I color-coded transactions the way I always did at work. Habit took over. Training kicked in. Emotion stepped aside. When I cross-referenced the withdrawals with my grandmother's handwritten calendar, my chest tightened. Every withdrawal occurred within 48 hours of a visit from my mother. Not once, not twice. Every time. That was the moment the accusation stopped making sense. If my mother truly believed I was unstable, she would have moved sooner. Filed earlier. Raised concerns while my grandmother was alive. Instead, she waited until after the funeral. After probate began. After she learned she had no authority left. Desperation doesn't make people creative. It makes them sloppy. The recess ended. We returned to our seats. The judge called the room to order. My mother avoided my eyes now, not out of guilt, but calculation. She was trying to figure out how much damage had already been done. She didn't know the answer. Because I hadn't just found suspicious withdrawals. I'd found patterns in behavior. My grandmother's records, once meticulous, became inconsistent near the end. Receipts missing, envelopes misfiled, notes abruptly vague. That wasn't decline. That was interference. Someone had been helping her, too much. And once I understood that, the accusation against me became almost laughable. This wasn't about my mental fitness. It was about controlling the narrative before anyone else followed the trail. Because if the court stopped asking whether I was competent and started asking who had access to my grandmother's money, everything would collapse. And the deeper I dug, the clearer it became that my mother hadn't acted alone. And the next name I uncovered would change this from a family dispute into something far more dangerous. Once you notice a pattern, you can't unsee it. Back at my apartment after the hearing, I spread everything out across the dining table. Bank statements, calendar copies, transaction logs. Not in piles, in sequences. Order tells the truth faster than emotion ever will. That's when I noticed what wasn't obvious. My mother's name didn't appear on most of the withdrawals. At first, that felt wrong. Convenient, even. But convenience is rarely accidental. The transactions didn't list her as an authorized user. They didn't list anyone familiar. Instead, the money moved in short, indirect paths, temporary holding accounts, quick transfers, clean exits. That's when one name kept surfacing. Not loudly, not repeatedly, just enough. Mark Henson, my stepfather. The man my mother married less than 4 months after my parents' divorce. The man who never tried to parent me, never attended a school event, never spoke to me unless necessary. The man who always stood half a step behind my mother, letting her speak while he watched. On paper, he was nowhere. In practice, he was everywhere. I pulled public records, property filings, business registrations, old LLCs that dissolved and reappeared under slightly altered names. Same addresses, same accountant. Same pattern of short-term debt followed by sudden relief. Money in, money out, always just in time. People like Mark don't plan crimes. They react to pressure. And pressure leaves fingerprints. When I lined up the dates of my grandmother's cash withdrawals with Mark's financial activity, the overlap was unmistakable. Refinanced loans. Missed payments suddenly resolved. Accounts brought back from the edge. My grandmother's money hadn't vanished. It had been absorbed. That realization reframed everything. My mother wasn't the architect. She was the doorway. Mark was the one who understood systems, who knew how to stay invisible, who knew that accusing me was safer than challenging the estate directly. And once I saw that, something else became clear. This wasn't his first time. I found a court record from another state, sealed but referenced. An elderly relative, power of attorney. Assets diminished quietly over time. No charges filed, no conclusions reached, just questions that stopped being asked. That's when the fear set in, not panic, not anger, but precision. Because if Mark had done this before, then my grandmother wasn't an exception. She was a pattern. The next day, I met with my attorney and showed her everything. She didn't interrupt. She didn't reassure me. She just listened. When I finished, she said one sentence. "This stopped being a probate issue days ago." She was right. By accusing me, my mother had forced the court to look closer. And by doing that, she dragged a much bigger truth into the light. One that couldn't be dismissed as family drama. One that carried consequences. Because once I identified who benefited from the missing money, the next step was inevitable. And the evidence I uncovered after that would make it impossible for anyone to walk away. Once you know who benefits, the next question is always how. I didn't accuse anyone. I didn't confront my mother. I didn't even return her unanswered calls. Confrontation warns people. Evidence traps them. Instead, I went to the bank. My grandmother had been old-fashioned in the best way. She trusted institutions. She kept records. And years earlier, after a minor break-in scare in her neighborhood, she'd added my name to a safety deposit box just in case. I hadn't thought about it in years. The banker didn't hesitate when I gave her name. She smiled softly, the kind of smile people use when they recognize someone they respected. "We haven't had anyone access that box in a while," she said. That should have reassured me. It didn't. The box was heavier than I remembered. Inside were the things I expected, documents, a small amount of jewelry, neatly folded papers tied with string. And one thing I didn't. A manila envelope, unmarked. Inside it was a single document, a power of attorney. I sat perfectly still. The paper looked legitimate, proper formatting, correct language, a signature that resembled my grandmother's handwriting, dated 9 months before her death, granting full financial authority to my mother. I hadn't known it existed. Neither had the estate attorney. That alone was a problem. But I didn't look at the signature first. I looked at the notarization, because signatures can be pressured. Stamps cannot lie. The notary's name triggered something in my memory, not personal, professional. I'd seen it before, years earlier, in a compliance review. I pulled up the state registry on my phone right there in the vault room. The notary's commission had expired 3 years before the document was signed. My breath slowed. This wasn't manipulation. This was forgery. Someone had taken an old stamp, applied it to a new lie, and used it to drain an elderly woman's finances under the illusion of legality. And suddenly the accusation against me made perfect sense. If this document was exposed, everything unraveled. The withdrawals, the timing, the panic, the sudden need to discredit the one person trained to recognize fraud. Me. I copied the document, logged its existence, returned everything exactly as I found it. Then I called my attorney. I didn't explain. I didn't speculate. I said one sentence. This document should not exist. She understood immediately. Her advice was short and chilling. Do nothing. Say nothing. Let them believe their story is working. Because people who think they're winning make mistakes. And the mistake my mother and Mark made next would be the one that ended everything. Because once forged authority entered the record, this stopped being about inheritance, and the next move would bring consequences neither of them had planned for. There is a particular kind of calm that comes when you stop trying to correct a lie. After I found the forged document, I didn't rush to court. I didn't demand explanations. I didn't warn anyone that I knew. Instead, I did exactly what my attorney advised. I became boring. We filed a restrained response to the petition. No accusations, no counterclaims, no exhibits. Just a clear denial of incompetence and a request for a formal hearing. On paper, it looked like a weak defense. No emotion, no fight. My mother relaxed almost immediately. She started calling again, leaving voicemails heavy with rehearsed concern. I just want to help you, she said. You don't have to do this the hard way. The messages weren't for me. They were for the record she believed was being built. Her attorney followed the same rhythm. Requests for evaluations. Casual suggestions that cooperation would resolve things faster. Every word was designed to corner me into validating the accusation. I declined politely. Silence makes people careless. During my deposition, I dressed down. No sharp lines, no confidence signaling. I answered questions simply: education, employment, a brief acknowledgement of counseling as a teenager. No elaboration. No defensiveness. When asked whether I'd ever been declared unfit, I said no. When asked whether I felt emotionally affected by the situation, I said yes, minimally. From the corner of the room, I watched my mother soften. Her posture loosened. She thought I was folding, that I was overwhelmed, that the pressure was working. Mark sat beside her, silent as always, observing, calculating. He didn't smile, but his shoulders dropped just slightly. That was the moment I knew we were ready. Because while they focused on proving I was unstable, they stopped paying attention to themselves. Behind the scenes, my attorney had done exactly one thing. She forwarded the forged power of attorney to the appropriate office. No drama. No narrative. Just documentation and a quiet request to verify. That's how you trigger real scrutiny. Authorities don't respond to outrage. They respond to inconsistencies. And forged notarizations are not inconsistencies, they're alarms. Days passed, then weeks. My mother grew bolder. She filed supplemental statements. She pushed for expedited rulings. She believed momentum was on her side. She never asked why no one had scheduled my evaluation yet. She never asked why the bank had gone quiet. She never noticed that Mark's accounts were suddenly harder to access. Because when people think they've already won, they stop checking the locks. The night before the hearing, I slept better than I had in months. Not because I knew the outcome, but because I knew the process. Truth doesn't need urgency. It needs time. And time was finally on my side. The next morning, the courtroom filled faster than expected. And when the judge asked one simple question, everything my mother thought was secure began to collapse at once. Courtrooms have a strange rhythm. Most people think the loud moments matter, the objections, the raised voices, the emotional testimony. They don't. The real turning points arrive quietly, disguised as routine. That morning, the room filled faster than it had before. Not with spectators, but with attention. People sense when something is about to break, even if they can't explain why. My mother arrived late. Confidence can do that to people. It convinces them time will wait. She sat beside Mark, smoothing her jacket, avoiding my eyes. Her attorney stacked his papers carefully, like a man who believed the ending had already been written. The judge entered without ceremony and got straight to it. My mother's attorney spoke first, repeating the same narrative: concern, instability, responsibility. He spoke as if nothing had changed since the last hearing. But something had changed. The judge listened without interrupting. She didn't take many notes. That alone was unsettling. When he finished, she didn't respond right away. She turned a page, adjusted her glasses. Then she asked a question that sounded harmless. "Counsel," she said evenly, "are you aware of your client's access to the decedent's accounts prior to her passing?" The room stilled. The attorney hesitated. "To my knowledge, Your Honor, any access was informal and limited." The judge nodded slowly. "And are you aware of a power of attorney executed 9 months before the decedent's death?" My mother's head snapped up. Mark's jaw tightened. The attorney blinked. "Yes, Your Honor. That document has been on file with the bank." "Indeed," the judge said. "And are you aware that the notarization on that document was invalid at the time it was executed?" Silence landed hard. No gasps, no murmurs, just absence of sound. The attorney turned toward my mother. She stared straight ahead. Mark didn't move. The judge continued, calm as ever. "I ask because this court has received verification that the notary's commission had expired years earlier, which means this document should not exist in lawful form." My mother shook her head once sharply. "That's not possible." The judge finally looked at her directly. "It is not a matter of possibility, Miss Hart. It is a matter of record." She turned back to the attorney. "Given this information, do you wish to proceed with the petition claiming the respondent is mentally incompetent?" The question hung there. This was the moment. The last exit. The attorney stood slowly. His voice had changed. "Your Honor, we would request a brief recess to confer with our client." The judge nodded. "Granted." As they leaned toward each other in hurried whispers, my mother finally looked at me, not with anger, not with triumph, but with something else. Recognition. She understood now. This had never been about my stability. It had been about her exposure. Because when court resumed, the petition wouldn't be the only thing on the line, and the consequences that followed would be impossible to contain. The recess lasted less than 10 minutes. That was how I knew there was no plan left, only damage control. When court resumed, my mother's attorney stood again, but the confidence was gone. His voice had thinned, stripped of its earlier certainty. "Your Honor," he said carefully, "after consulting with my client, we are requesting to withdraw the petition." A ripple moved through the room. Not shock, relief. People love tidy endings. They love believing uncomfortable things can simply be erased with the right paperwork. The judge did not share that instinct. She looked at him for a long moment, then shook her head once. "No," she said calmly. "That will not be happening." The word landed with finality. She continued, her tone measured, precise. "This court is not prepared to allow a petition alleging incompetence to be withdrawn when evidence presented raises credible concerns of financial exploitation and fraud." My mother opened her mouth. The judge raised a hand without looking at her. "You have spoken enough today." That was it. No shouting, no lecture, just authority. The petition was denied with prejudice. The language mattered. It meant there would be no second attempt. No rewording. No future version of the same accusation. Then came the part my mother hadn't prepared for. The judge ordered the evidence referred for further review. Not optional, not delayed. Copies forwarded. Records preserved. Each sentence closed a door. By the time she finished, my mother was no longer angry. She was frozen. Court adjourned without drama. No gavel slam, no grand declaration. Just paperwork being gathered and people standing up, unsure how to process what they'd witnessed. Outside the courtroom, the air felt lighter, like pressure finally releasing. My attorney stepped aside to make a call. My mother walked past me without a word, her eyes unfocused, clutching her purse as if it could anchor her to something solid. Mark followed, rigid, silent, already calculating what could still be salvaged. There was nothing left to salvage. The weeks that followed were quiet. That's how real consequences move. Slowly, thoroughly, without spectacle. Accounts were reviewed. Access was frozen. Questions were asked by people who don't ask them twice. I wasn't contacted much. I didn't need to be. My role was already finished. The estate was settled properly, according to my grandmother's wishes. I kept the house. Some things aren't meant to be liquidated. Life didn't become perfect afterward. It became steady. The kind of steady you earn. People sometimes ask how I stayed calm when my own mother tried to dismantle my life in public. The answer is simple. I didn't stay calm because I was strong. I stayed calm because I was prepared. Because I understood something she never did. That truth doesn't need to shout. It doesn't need to rush. And it doesn't need permission to surface. Silence isn't weakness. Sometimes it's the verdict. And if you've stayed with this story until the end, paying attention to the quiet turns instead of waiting for explosions, you already know that the most powerful outcomes rarely announce themselves. They simply arrive. And once they do, there's no going back.